Hello, good afternoon. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. I also have a good topic for you today. So, I'm going to be talking about a particular scenario, and that's if you came into the United States on a K-1 fiance visa. You're here, you got married, maybe you didn't about different scenarios here. And now your spouse is a completely different person. They're possibly a monster. They are not what they projected themselves to be when you first got engaged with them. And then when you came to the United States, at some point they changed. They started to mistreat you. And this could be emotional, it could have been physical, could be in financially. Now, physical doesn't isn't required here for you to have options. The first thing I want to start with here is you have options. This just because you came on the fiance visa does not mean that this person owns you, that they have a say in your destiny here. You are you're the only person that can control your destiny, even when it comes to immigration. And your number one priority should be your safety and your well being. I know a lot of people come here and they come here, they feel like they're beholden to the fiance, the citizen fiance, because the fiance is the one that filed the petition. And so when they're dealt, they now have to face the uncertainty of, leaving this person that took them here on the fiance visa. They think that's just not an option, especially when they don't want to be here without status. The option here, I'm going to talk about two options, and this is because this happens, and I want to bring awareness to this issue. You know about it, but you can also tell others. Maybe you know somebody who's going through it. You can tell them they have options. So the first option is VA. Now, if you came here, you came here on the K-1, then you got married, you may be going through the green card process now. So actually, talk about three options based on three different areas. So you came here, you got married after you came here, you went ahead and filed for the adjustment of status process to get the green card, to finish out the process. But your spouse is being manipulative. They're mistreating you. They could be mistreating you in different ways. If you're being mistreated, you know you're being mistreated. You're not crazy. Okay. If you feel like you're not being paranoid, you're not being crazy, it's not your fault. They are mistreating you, and this qualifies you for your own relief. Now, once you've come to the conclusion that you are being mistreated, they're not treating you the way that you're supposed to be treated, it's time to evaluate those options. Now, under VAWA, you're able to move that process, even though, yes, you came on the fiance visa with that fiance, you can still move that process over to VAWA, and you can continue to get your work permit, continue to get your travel document, same as before. The only difference is that now your process, it's a confidential, and your fiance will not know about this. They know the focus here, once you file for VAWA, the focus here is your protection and the protection of your safety. So the immigration does not write to the petitioner, which is a U.S. citizen spouse. They're not going to ask them to sign anything or verify any information. They're going to go by whatever evidence presented. We help our clients to understand what's required, and we help our clients to put the right evidence together that will be acceptable for this process. Just know that you have an option here. The other scenario here is you came here, you got married, and you got the permanent residence, but you got your 2-year permanent residence, right? That means that now you have to go back and get the 10-year. Usually, when you're in that situation, you do have to apply jointly with this spouse. And if they're mistreating you, chances are you're in a situation now where you know that may not be a possibility, or you may not want them to apply with you because you don't trust them. I've said this repeatedly, that if you don't trust your spouse to go through the process with you, consider VAWA, because if you don't trust them, it means that they could very well come back and sabotage your process. And you don't want that, because then your case gets a lot more complicated. But now you have to go ahead and do what's called removal of conditions. It's removing the temporary conditions on your green card to get the 10-year. To jump through that hurdle, you have to jointly apply with your spouse, but there is an exception here. And the exception is that you can apply based on the mistreatment. And it is also under VAWA that you're allowed to do this. It's also confidential, whether you're still with the spouse or you're separated or you're even divorced. Now, there's also the last scenario here. And the last scenario is you came on the K-1, you did not get married. They got you here, you didn't get married. Turns out their intention was not to marry you, and now you're stuck. Now, does present a difficult situation, because if you walk away from that situation without a plan, or without knowing what your rights are, or without taking the proper action, you could find yourself stuck here. Because once you leave the situation and you're on one visa, you are barred from doing adjustment of status, except where if you marry that same spouse and move forward. If you do this, and then say you leave that marriage and you marry somebody else, then guess what happens? You're barred from adjustment of status with that next spouse. So you'd have to be very careful about what your legal rights and options are in this case. Now, it depends. Your options here will depend on what transpired in the marriage, where facts are going to be very important. This is why I urge you, even when you think you don't have options, call and get legal advice, because where you think there's no option, guess what? I, as the attorney, I know that there is an option. And in some cases, I'm able to find that when I see that the whole motive of the was to bring you here on the fiance visa, and then have you here for their purposes, have you here to clean or cook, or have you here for their sexual needs, then that could qualify you for the T status, because that's a type of trafficking, right? They took you here under the false pretense that they were going to marry you and live happily ever after and live life the way you should and the way that you deserved. But when you came here, they had the motivation to get you to do things that you did not agree to, that you were not willing to do. But now they have you in this situation where you feel stuck, you can't leave, and so you feel like you have to do this stuff for them. You work for them in the business, work in the house, attend to their sexual needs even when you don't want to. You might find that they are voraciously demanding sex from you, that maybe they have an on a child, a disabled child, or they have children, that now you find that you're the one that's taking care of the children in the house when you didn't sign up for that. This is a form of trafficking. And so even if you came on the K-1, even though you will be barred from adjustment of status, through if you leave and remarry, or through another way, you can still apply for T status under this scenario, right? Because this person used the immigration process, abused the immigration process to just here and use them for their own purposes. All right, so that's what I have to tell you. I'm going to leave it up to you to get the help you need, right? So important to evaluate your options. If you're feeling stuck, with someone, don't just stop and say, there's no way out of this. Call me, schedule an appointment, and we can talk about what those possible options could be going forward. You can find the number on the screen here on YouTube, Facebook, and Twitch. And see the phone. If you click on the link in the profile on Instagram, you'll see, if you go to the link, you'll see the link to the website, the number is there, the contact form is there, the online chat is there. And the phone number is also all over my videos. Go ahead. I'm leaving it up to you to get the help you need. That's the best thing you can do when you're in a situation like this. Now I'm going to go ahead and answer some questions before I head out again. So go ahead and put your questions in the comments and I'll answer. So Sue, go ahead, put your questions in the comments and I will answer your question. So how can I apply H1? And I think this is an H1B visa. So it's going to depend on the employer. You do have to have certain qualifications, and the H1B is for individuals who will be working in specialty occupations, as well as very specific work requirements. So it really is up to the employer to determine whether they're going to sponsor you for that. Can my spouse stop my green card case when I am waiting on approval? Yes, they can. However, you can continue your own process through follow-up. So yes, absolutely. This is where you should definitely make decisions for your own protection, because a spouse can sabotage your process. They can stop your process from going forward unless you take actions to protect yourself. And that's usually through follow-up. I filed my mom. I think I filed for my mom and she got a green card. She has an underage daughter who has a visitor visa. Is there a way she can change her daughter's status since my mom just got her green card? Give me a call, schedule an appointment. There is a possibility, but I need to understand timing is everything here. If your mom is a green card holder, your daughter is under the age of 21, she's here on a visa, it's an emergency. You need to make sure that you apply before her time expires, that the time that they've given her expires to do a change of status. But timing is everything, and the conditions all have to be right. So this is where you need to get assistance, because I've seen people do this wrong and it turns into a big problem. So you want to make sure that you understand. Follow the instructions, go to the link in the profile to schedule your own appointment, or call the number. If I have an AOS pending, can I apply for Medicaid? Now, just when you're applying for Medicaid, be very careful about, make sure you qualify. Make sure you're very upfront about your immigration status. It may be possible, depending on the circumstances here. And Medicaid, it's dependent on your individual circumstances, maybe your income, your current immigration status. For example, emergency Medicaid is what's used for immigrants. So are you in an emergency scenario? And then it depends on the state. Sometimes you can get medical assistance, sometimes you can't. So just make sure you're honest about everything so that they can make the determination about whether you qualify. Does a child over 21 qualify for VAWA? So if the child is over 21, they have up until they're 25 to apply, as long as they can show that the delay in applying for the VAWA was somehow related to the mistreatment, which in many cases it is, because the parent had a lot of control over the child, and maybe because of that, it affected their ability to apply for permanent residence. Can someone with diplomatic visa get a green card in the US? Um, Now, a visa is granted outside of the country. Can they change status? It's going to depend on what type of status you're changing for to. My BFF has a boyfriend and he's not working right, nor have he ever paid taxes. He's a US citizen. They have been together for 3 years. Can he petition for her? He will probably need a joint sponsor. Um, how can someone who overstayed his B1, B2 get a green card? Oh my gosh, that will take me a whole week to talk about. And whenever someone overstays, the options do become very limited and it becomes very fact based. So this is what you need to make sure you understand and schedule a consultation, because the possibilities are limited, but I need to understand what is the situation, what are the circumstances surrounding the overstay, and so forth. If you're in the US on a J1 visa, can you change your status while in the country? In some cases, if you're subject to the 2-year foreign residency requirement, then you have to apply for a waiver first before changing status. So if your B1, B2 visa got canceled with CWOP, Penmark, and it was racial profiling, who do you go about it? What are the odds of getting back this at their first attempt? So this is a complex question. So if the conduct of the officer was improper, you would have to go through a complaint process for them to look into what happened and to be able to address it. So if there was no legal basis to cancel the visa and it was just simply based on race, then you'd have to go through a different avenue. This is not the usual type of legal issue that comes across on a regular basis, and so they would have to investigate what happened there. A VAWA case in filed a VAWA case in 2021, and priority date is in 2025. It takes 5 years. So yeah, so with VAWA, you can get approval before those 5 years, but to get the green card, to actually get the ability to apply for adjustment of status, you're going to have to wait for your priority date to be current. So it doesn't mean that VAWA itself, because VAWA is a special status that you get where you get your work permit, you continue to get you can apply for a travel document until you get the green card. All right, so that's gonna be it for me today. Thanks so much for your time. I'll be back tomorrow at lunchtime to answer some more questions. But if you want to know what your options are, this is where I'm gonna leave it to you to schedule the consultation. Have a good one, guys. See you tomorrow. Bye bye.